So, but before we get to our distinguished panel, we have IP in the news. And today we're going to be talking about trademarks. Elizabeth, can you trademark the sound of a beer can opening?
I know the answer to that. Honestly,
yeah, we talked about it before
you can trademark a lot of sounds. We did one show where we went through all these trademark sounds and had people try to guess what they were. But I know the answer to this one, according to the United States Patent and Trademark
All right. Well,
Office.
I'll share it with I mean, it is kind of a matter of common sense, but the fact is that Anheuser-Busch actually tried to register a trademark for the sound of opening a can of beer. So obviously the trademark office denied it, but there's a little bit of a funny story here. I want to tell you how they described the sound in the trademark application. It says the mark consists of a clicking sound followed by a period of silence followed by a deeper clicking sound. Now that's pretty specific, don't you think? I mean, that's very, that could have not apply to anything, right? No, it's too generic. It's functional. There's like 1,000 reasons why the trademark office denied the mark. But what is also funny is that the trademark office examiner did a video and he lined up 4 beer cans along with a Coke can. And he did a video opening 4 different kinds of beers. And he said, and then the Coke can, of course, and he said, see, they all sound the same. So it's generic. You can't get the trademark. He made a video of this and put it in the record. And the sad part about this story is that the trademark office would not pay for the alcoholic beverages he used in his demonstration, but they did pay for the non-alcoholic beverages. So there's some sort of policy out there floating around the trademark office that you can't use alcoholic or you can't be reimbursed for alcoholic beers. So anyway, the moral of the story is you can't trademark the sound of a beer can opening. I'm sure that's something that our student presenters would have no knowledge of anyway in the show. But I would also say that it is possible to trademark sounds. They just have to be distinctive and specifically associated with your brand. So that being said, it's time for the roundtable. Sandy, what are your thoughts about this whole story?
I wonder how the Budweiser legal attorneys actually had the gall to try to trademark that. If it was outside counsel, I wonder how much they paid them. If it was inside counsel, maybe they need to rotate their counsel a little bit. But, you know, listen, you guys are the experts in this area, but that seems pretty far out, man. I mean, that seems really crazy, man.
I can just imagine, Sandy, it came from the marketing department.
They got nothing else to do. They got no other ways to market their products than to go for the sound of a beer can opening. How generic can you be?
And then what are you going to do? You're going to sue all your customers that drink different brands of beer?
And Coke and Pepsi.
So how do you enforce it?
I know, it's ridiculous.
How could you possibly enforce that? I mean, that would be the red letter day for the attorney to send out cease and desist letters, you know? I mean,
to
really?
300 million people.
I'm going to get sued because I drink a beer? Really?
So anyway, it's hilarious. So Chaim, what are your thoughts about this from an academic perspective?
Purely from an academic perspective. Actually, I'm curious because earlier on you said you did a show where you went through all these different sounds that were trademarked. In your experience, what's the kind of most interesting or unique or crazy sound that you guys have seen trademarked?
That's an interesting question, and to be perfectly blunt, we haven't filed that many trademarks on sounds. We've filed a couple on perfume scents, which you can also trademark, but sure, we haven't filed it on sounds. The most unusual one would probably be I would say, what would be the least expected? I would say probably the the NBC logo is probably the most famous.
Ding, 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 like the
Mm.
ding,
Dum,
ding.
dum, dum. Yeah, you have
Yep.
to have a sense of pitch to be able to.
Which I don't possess.
But no, that's a good question. There's, it's really kind of difficult to get a trademark on a sound, and a lot of companies don't pursue them. There aren't that many marks in that area. For certain big institutions that have a real strong brand association, it does make sense. So
Yeah, you could copyright music, right? That's a sound, but that's a copyright. It's not a trademark.
right. So Sandy's absolutely right. And as a singer-songwriter, he knows that he's copyrighted some music. So I think, that's the more traditional way to go, though. Sandy's right, is with copyright.
So on to Noah.
Noah, what are your thoughts?
Sure. I guess I think that's really interesting that they would attempt to do it. I mean, we're here talking about it now, so maybe they saw it as, if anything, we get some publicity out of it. But it makes me think about like trademark trolls as well, about these people that go out looking specifically about how they can get a trademark to abuse it, or maybe do something that isn't necessarily furthering their business.
Yeah, I mean, that's an important consideration. And I like the way you're thinking strategically there, because there are times to do things not just for the purpose of actually getting the mark. I mean, maybe they had a bet or something in the legal department, who knows? But there's times when legal processes are used for public purposes too. So that's a good point. Greta?
Yeah, I actually had two initial thoughts on this. My first one was when you were talking about how the trademark, if it was specific to the brand, maybe it could be trademarked. And maybe this is a segue for them to make a special beer can opening sound that then they can trademark.
There you
Who
go.
knows? But then I also had a question on some of your past podcasts. You've talked about how trademarks are used on different mediums, right?
Mm-hmm.
What medium were they trademarking this for?
Well, they would have been trademarking it. So once you get a trademark, and in the case, let's just say hypothetically, they did get the beer can sound trademark, which of course would be completely ridiculous. But then any medium where that sound is heard, in a bar, at home, on a commercial, any of those places could be potentially places where the trademark would be enforceable. So it's really it's when you get a trademark, it's based on how it's used, not necessarily where it's used. And so so does that answer your question?
Yeah, it does.
Okay, cool. So
Great thoughts, everybody.
yeah, great thoughts, everybody.
Now I want to hear from Sandy.
Yeah.